Lordship, I beg to mention item number 4 to 7, Your Lordship.
Hmm.
Lordship, in this matter, we have filed our wakalatnama, but our names are not shown yet.
Wakalat number 4.
For the accused person in item number 4 and the petitioner is in item number 5 to 7, Your Lordship.
So that would be respondent 2 in item 5.
Yes, yes.
Respondent 2.
Respondent 2.
Respondent
Yeah.
2 in item 4.
Item 4, Your Lordship.
In item 5, petitioner.
Item 5, petitioner, Your Lordship.
Who's appearing for the other side? Anybody? Learned counsel, she such and such, submits that they have entered appearance on behalf of the respondent number 2 in criminal petition 52 of 24, and for the petitioner.
Yes, Your Lordship.
Petitioner in the other case, and for the petitioner in which one? Case
5 to 7. 5 to 7, Your Lordship. Item number 5 to 7 for
For
the
the
petition.
petitioner in criminal petition 1823, 3723, and the anticipatory bail also,
Yes, Your Lordship.
and the anticipatory bail 1 of 2024. So, however, their names are not reflected in the cause list. So, the registry is directed to reflect the names of the learned. Give your name.
Yes, Your Lordship. S. Gautam, Your Lordship.
Spell it.
S. Gautam. Gautam.
Reflect the name of such and such in the cause list as counsel appearing for the accused and the petitioner as stated above. No, accused and the respondent as stated above. So you also.
No, Lordship, I'm
Okay.
just waiting
Okay.
to make a mention.
Okay. List accordingly when?
Lordship, after 4 weeks, Lordship.
So accordingly after 4 weeks, reflecting the name of the learned counsels. Yes.
Yes, Your Lordship.
Yes.
May I please, Lord?
Yes.
Lord, I may be allowed to move one unlisted motion, today being the last day. I have mentioned in court number 1, and I have indicated and informed the court that this is a bench pay matter pertaining to anticipatory bail. So if your Lordship places, then I can mention in court number 2. My Lord has graciously granted to make a mention before your Lordship. So I may be allowed to move an unlisted motion after the part
listed
1
matters.
matters. Yes, Lordship.
Your lady, similar prayer. I filed a writ petition yesterday. Not listed, I mentioned before 1. But then I'm told the court number 1 is raising early. So he had direct
Okay.
me to.
May it please, my lord.
Yes.
Lordship, I've also been sent to court too. There's an urgency in my petition.
Unlisted.
Yes, unlisted. Deeply obliged.
May it please your lordship, I beg to mention herein item number 12, your lordship. Due to some personal difficulties, the leading counsel B. Ali SK have not appeared today before the court. If the matter can come up on 27/7/25, your lordship.
7 July.
Yes.
For CJC.
Yes.
Learned counsel, Miss your name?
Kim Kiana.
Kim Pen, appearing for the petitioner, submits that the leading counsel, Mr. B. Ali SK, has some personal difficulties today and is unable to appear. Accordingly, please for listing the matter on 27th July for hearing. Learned counsel appearing for the CGSC has no objections. List the matter on 27th July. It's brief.
Much obliged.
May I please, your lordship?
Yes.
Lordship, I beg to mention item 11. Lordship, I'm
Yes.
appearing on behalf of PN Sharma, the counsel for the respondent. Lordship, kindly allow us 2 weeks time to file objection in IF for continuation of delay.
I-11.
Yes, lordship.
Third learned counsel, Mr. Such appearing on behalf of Mr. B. N. Sharma, learned counsel for the respondents. So he has made a prayer for adjournment for 2 weeks.
Yes, Lordship.
For 2 weeks in order to file the objections in IA 11 of 2025. So prayer is allowed. This is the matter after 2 weeks. Learned counsel for the petitioner's appellant is present. Yes.
Bless your ladyship. Your ladyship, I'd like to mention item 3, contempt.
Mm.
Let this matter become of vacation.
Petitioner.
As Lordship, I have a submission to be made, Your Lordship. Regarding the time sought by the respondents attempted the objection, but then on the next listed date, Lordship. This court is graciously granted 2 times to bring the status report regarding the 4 divisions whether payment has been made.
Yes, yes,
So this
yes.
be the last chance, Lordship.
What happened? So much.
I'm yet to
time.
receive instruction, that is one.
Learned counsel, Mr. Moimchan, appearing for the respondents number
5, 6, and 7.
6.
5, 6, and 4, has prayed for 2 weeks' time to receive further instruction regarding the payment of arrears, was it?
Let's draw the errors.
Payment of less drawn pay arrears in respect of 4 divisions. So, learned counsel for the petitioner submits that enough opportunity has been given to the respondents to receive the instruction, and therefore this may be a last opportunity. Stop. Prayer is allowed, however, as a last chance, we'll give you 3 weeks. 3 weeks' time is given to the respondents to comply with the directions of this court. Stop. At least after 3 weeks.
Natural.
For motion, item number 1.
May I please, Lordship. The extent make appeal is filed under section 173 of the Motor Vehicle Act 1988 against the imputed judgment order dated 7/9/2024 passed by the learned tribunal motor accidental claim Dimapur, Nagaland in MAC MSC case number 99/2017
Continuation.
for enhancement of.
No, you have a prayer for continuation, isn't it? Delay.
Yes, I filed.
177. 177 days.
Yes, my lord.
Alternate counsel for the appellant, Mr. Pakun Chapu, stop. This is an application under section 5 of the Limitation Act 1963, praying for continuation of delay of 177 days in preferring the connected MSC appeal. Stop. Issue notice to the respondents 1, 2,
3.
1, 2, and 3. Returnable within 4 weeks. Stop. The petitioner the appellant shall take steps for notice on the respondents through registered posts as well as usual process within a period of 3 working days. List of the folks.
Hello, Patman.
For admission, item number 8.
May it please your Lordship. Your Lordship, I have a prayer, Your Lordship. I have not implemented certain necessary parties in my IA and my MSC appeal. So kindly give me an opportunity to implement the necessary parties by filing an IA in the interest of justice.
Lordship.
On the other day also, I have raised
Yes,
certain
yes.
objection on this in this regard. Lordship, the prayer for implement has come after I filed my objection. Yes. And secondly, Lordship, if
It's not possible at all.
Yes.
It's after objections are filed, how can you make the corrections?
Your lordship,
We'll,
if
we'll hear you. We'll hear you on merit.
Yes.
Are you ready today?
Your lordship, if I may state that
Yes.
under the CPC order 1 rule 10 of the CPC, if I may read, your lordship.
Yes.
Order 1 rule 10, suit in the name of wrong plaintiff. Where a suit have been instituted in the name of the wrong person as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff, the court may at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake and that it is necessary for the determination of the real matter in dispute, so to do, order any other person to be substituted or added as plaintiff upon such terms as the court thinks just. Clause 2, court may strike out or add parties. The court may at any stage of the proceeding, either upon or without the application of either party, on such term as may appear to the court to be just, order that the name of any party improperly joined, whether a plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit be added.
Okay, what you do is you file an IA and the court will see whether that can be admitted or not, okay?
Okay, your
You
lordship.
don't need the permission to file an IA.
Okay, your lordship.
You will just say, list after the summer vacation.
Okay.
List after summer.
Much
In the
obliged, your
meantime,
lordship.
you do the needful and then the court will consider when the IA is filed.
Okay, your lordship. Much obliged, your
Yes.
lordship.
For admission from the supplementary course list, item number 13.
May please, Your Lordship. This is otherwise a contempt matter, and this matter, Your Lordship, will come to the date of the judgment. It was passed on page 15. On 7th of February 2024, there was an order for payment of compensation. Page 15. By the division bench. Also, we'll see the date. On 7/2/2024, an order was passed. And this is regarding land compensation, some property damage compensation. Now, what has happened basically, in short, payment has come. The money was supposed to be sanctioned by the Union of India. The money has come. The money has reached the concerned deputy commissioner of this area, Kohima area. Now, the deputy commissioner, we have also implemented him as a respondent number 5, the new commissioner. Now, he is not complying with the court's order. He has been represented by counsels. They have filed their wakalatnama. Now, the difficulty as of now is he is trying to reopen the entire thing. If Your Lordship will see the judgment, I can just place few paragraphs of the judgment. The amount has quantified. There is no dispute regarding the amount. In fact, the compensation to be given to the landowners, whoever are there, that list is also there before this honorable court. Now, after that, this new deputy commissioner who is supposed to make the disbursement is only supposed to see whether the person is the real person or not, to verify his Aadhaar card and all. Now, what he is doing, my specific instructions from my clients, what he is doing, he is trying to reopen the entire gamut of the issue. He is trying to go for land verification as to where the damage took place. This damages pertains to 2017. Some terrace farmings were damaged, some houses were damaged when rose construction was there. Nothing is there now on that place.
That chapter is already closed.
Already closed.
With this DB on.
Exactly. This honorable court judgment have categorically looked into that aspect, have looked into that assessment sheet, the amount, the quantified amount, the compensation beneficiaries, and have also categorically held after a contest that the amount is not disputed and this amount has to be paid. The Union of India has sanctioned the money. The money is now just supposed to be disbursed by the deputy commissioner. He cannot therefore circumvent the court's order and consider himself to be a court of adjudication and then start adjudicating on the very merits of the fact itself. So therefore, it is a very serious issue. The new deputy commissioner has to answer before the honorable court, and I would pray that his personal appearance may be called for on the next date. And he is represented by counsel. He is represented. Lordship, I have seen his file. Wakalatnama has been filed by Advocate G. Zivomi.
Who's appearing? Or respondent number 5?
May I please, Lordship,
My lord,
And another aspect, this particular issue of compensation is related to other areas also. And in all those areas, judgments have been passed similarly and payments have been disbursed. It's only in this particular area an amount of 4 crores 70 lakhs. The entire amount is 120 crores, Your Lordship. The entire 120 crores has been sanctioned by the Union of India and paid. Across Nagaland, it has been paid. Only for this small area, this deputy commissioner is creating a problem. So therefore, where people have got it, this section of people, amount of 4 crores 70 lakhs only is not been paid because of this kind of activities by the present deputy commissioner, respondent number 5, Your Lordship. And may I say this is definitely for vested interest. Yes.
Yes, may I please, Your Lordship. My lord, I'm appearing on behalf of Wizumomi, who is representing respondent number 5. Due to some personal difficulties, who could not appear today, my lord. So, my lord, he requested Your Lordship to list the matter after vacation.
Let the deputy commissioner appear on that day.
My lord,
But then the respondent has to know what kind of
yes, my lord.
directions have been passed by the court and what he has to do.
On right after vacation, the matter can be may be listed, and on that day he can explain everything, my lord. That by my learned colleagues, my lord. On 14, the matter can
14?
yes. On the 14.
Since the council is also
14
today,
is opening.
it's
Yes.
the opening day,
Monday.
Monday.
14, you can have this matter.
Yes.
But if Your Lordship will observe that if the positive steps are not taken, then personal appearance may be called for. At least some observation in that regard. At least let the deputy commissioner know that the courts are looking into this matter.
Learned counsel for the petitioner, Shri.
A. Sharma, Lordship.
Sharma. Learned counsel, Mr. Tipapong makes a mention on behalf of counsel, Mr. Victor V. Zimomi, who has entered appearance on behalf of respondent number 5 to list the matter on 14th July 2025, as he has some difficulties today. It is observed that the respondent number 5
Your Lordship will see page 16, the amount is quoted. Page 16.
Page 16.
Page 16.
Of the
Paragraph
judgment,
3
of the judgment.
Yes, of the contempt petition.
No,
Where
in
the judgment is yes, in the
also
judgment, in the judgment. In the judgment, Your Lordship.
Judgment, yes,
Paragraph 3.
paragraph 3.
Lordship will see the amount. Paragraph last portion. The assessment has come to the tune of. That is the assessment amount. And the area is Juneboto Chakabama Road in respect of Kohima district. And the amount is quoted. So this has not been paid. So Lordship will direct him to immediately take steps for disbursement.
Just delete that last line and say, has stated that such and such that regarding the time 14 July, you stop there. Then after that, by judgment dated 7/2/2024 in PIL 1 of 2023,
Yes, Your Lordship.
the state respondents had been directed to release the amount of rupees. This is 4 crore.
4 crores 70 lakhs.
70 lakhs.
9,719.74
9,719.74 to the affected landowners
of the Juneboto Chakabama Road
of the Zeneboto-Chakapama Road
in
in
respect of.
respect of Kohima
Yes, Your
district.
Lordship.
So, learned counsel for the petitioner submits that the Union of India has through the which ministry?
Ministry of
Through the
Road and Transport,
Ministry
MOT.
of Transport MOT has already released the said amount, but
And the money is lying with the deputy
and
commissioner.
the money is lying with the respondent number 5.
Yes, Lordship.
However, the same has not been dispersed till date. So it is directed that it is expected that the respondent number 5 shall disperse the said amount on or before the next date,
Yes.
that is 14/7/2025, and submit the status report before this court.
And Lordship, in default, Lordship will be,
We'll see.
if that observation is there, some kind of,
No,
this
the
it has to be
order is
there.
already there, so on the next day, we'll see.
Much obliged.
Oblige your lordship. On 14th, lordship.
Yes, 14.
For orders, item number 9.
Yeah, please, your lordship. Lordship, the judgment and order dated 28/2/23 has been complied. The petitioner has already received the compensated amount. So lordship may kindly close this matter, instant contempt matter.
Learned counsel for the petitioner, Ms. such and such, submits that the directions of this court has already been complied with and the petitioner has received the compensation amount of rupees 10 lakhs. Yes, 10 lakhs. So accordingly, prays that the matter may be closed. So learned counsel K. Angami is present for.
I'm appearing of Mr. N. Angami for respondent number 1.
is
1, 2, 3.
on behalf of respondent number 1.
1, 2, 3. 1, 2, 3.
1 to 3. So for respondent number 1 to 3. Okay. Accordingly, the matter is disposed of.
Much obliged.
For orders, item number 10.
May I please, lordship? My lord, I'm yet to receive instruction. Currently, allowed 3 weeks time already.
Last time also you
Yes.
asked for 3 weeks time.
Yes, my lord.
5, 6.
I,
Let this become a routine adjournment. What happened?
no, my lord, in fact, they have advised me to file the review petition. So I sought some clarification from there.
You have to advise them after
Yes.
contempt is filed. How can they file a review petition? You are there to advise them.
So that is why I've sought some clarification from them, my lord.
You have to give them the
Yes.
clarification. In fact. Yes,
At least 3 weeks time, I will grant them, my lord.
Internal Counsel, Mr. Tibapom, appearing for respondent number 3 and 5, has prayed for another 3 weeks time to receive instruction and to file his affidavit in opposition. Stop. Learned Counsel for the petitioner, 7 such present. Released after 3 weeks. Stop. It is expected that the respondents shall comply with the directions of this court by the next date, which is
Much obliged.
stop. It's not come down. Then we will just rise and then we'll come back again when it's ready. Call it adjourned. The petitions are not ready, so we'll just rise and come back after 10 minutes.
Maybe you want to bring up together? Maybe. I see. तो material मेरा जाने को दे। Number भेजा के चौके पे मेरा भेजा के दे।
कौन सा है? आप अपने मन के इतना दे दो।
I mean that 116 है। ये तम
हाँ, maybe 1B14.
ये अच्छा वो yeah right.
1B14.
I guess
Serial number will be 14.
Oh, okay.
Now, it will be the first. Oh, 21. Nearly 4. Now, For motion from the supplementary cost list, item number 14, anticipatory bail, anticipatory bail 21.
Earlier, the petitioner has approached the sitting judge Dimapur. And then yesterday it was rejected on the ground that on 23rd, when the order was passed, the petitioner was on his way to Shamatur for submitting training report. And incidentally, on the same date, he was directed to appear before the PS. And since he did not appear on the 23rd, the day on which the court has passed the order, and the day on which he was directed to be reported to the PS, he was on the way to Shamatur to submit his training report. But before that, Lordship, just to understand the background and antecedents of the petitioner, just by taking about 3 minutes, I will narrate. He joined in the police service in 1993 as a constable. And then in 2014, he was promoted to the post of assistant sub-inspector, that is police. And then in 2015, 1 year after his promotion, he was posted to Tipubar PS as ASI. And since then, he was working till he was transferred out. Now, on 23rd May, in Tipubar, some factional incident occurred. As Lordship is well aware, Tipubar, under the Tipubar police station, there are so many designated games. So there is chances of factional clashes and all that. So it so happened on 23rd May, incident took place. And then on the next day, since FIR was filed and then the police has taken cognizance and a case was registered, that is next day, 24th May. And then petitioner was entrusted to investigate the case. Before him, other officers were approached, but then there was nobody who was willing to accept. So ultimately it fallen on him. Initially, he also refused, saying that, look, normally the IO is headed by a sub-inspector. So I'm only ASI, so I may not be competent enough capable enough to investigate this. But then since there is order from the higher authority, he reluctantly accepted. That is on 24th May. And then on 25th May, a team of police led by the officer in charge of the Tipubar police station went to the complainant's house, and then inquiry was done. On that day, what happened? They wanted to enter into the house of the accused. But then there was some resistance by the factions, fully armed, and they did not retaliate it because it is a civilian area. So there will be, in order to avoid any casualty. So they have just retracted and then they returned. On the next day, that is on 26th May 2025, a team led by the Deputy Commissioner of Police, Chumukitima, a team was went to the place of occurrence. Now, they could not find the accused persons at his house. So they returned. And thereafter, the investigation was carried out. On 10th of June 2025, he went to the house of the accused, but then accused was not present. So he returned on that day, and the next day he went. And then he went, and then he was not there. So in the evening of 11, a telephone call came to his number from an unregistered number. And then, you want to take my statement? Yes, I will take your statement. Then you come tomorrow. That was on 10th. And on 10, he has left his contact number so that since he's not there, as and when he comes back, you inform me in this number so that I will come and take the statement. So that is the reason that the IO has given the contact number to the accused persons. That was the only ground. So on 13th, he was asked and then directed to submit the status report. So on 14, that is next day, 14 June, he submitted the status report of the investigation. Incidentally, on the same date, that is 14 June, he was transferred out to Shamator from Tibubar PS. So as I was mentioning, on 23rd, he went to Shamator to submit his training report. And then ultimately the application was taken up for hearing yesterday. And then the session judge has rejected his application on the ground that, look, on 23rd, you were directed to appear before the PS of Tibubar, but you have failed to appear on that. So, Lordship, may kindly come to page 17. This is the type copy notice under section 35, clause 3 of BNSS. By reading this, Lordship will find towards the end of the first paragraph, he was directed to appear on 23rd June 2025 at 1,500 hours. And repeatedly it is shown. And then Lordship will find in the bottom, when the order was passed, when the direction was issued. Direction was issued on the same day, that is 23/6/2025. So it was not possible for him to appear on the same date. And that is the ground which has been taken cognizance by the session judge.
Let's see the order. The order.
Order is at page 19. Where there? Order.
Who has accepted notice?
He is serving in the police department for the last 32 years, Lordship, and there is no criminal antecedents, nothing. But in view of this unfortunate incident, has been implicated. So he is seeking for anticipatory appeal. The petitioner is ready to cooperate with the investigation.
This is an application under section 482 of the BNSS, praying for grant of pre-arrest bail in respect of the petitioner. So, it is the case of the next part. It is the case of the petitioner that the applicant, the present petitioner was serving as ASI at the Tipupar PS, Dimapur, Nagaland. When a firing incident occurred on 23/5/2025 between the NSCN-K and NSCN-R factions at Unity Village, Jumukutima, Nagaland. Stop. Pursuant to this, an FIR was registered at Tipupar PS on 24th May 2025, being number 33/25 under section 33/304 clause 1/352/304 clause 2/3 clause 5. You just check out on the petition letter, okay? Such and such. Stop. It is stated that in connection with the aforementioned case, the petitioner was served, where is that notice?
Page 70.
Page. Yes, was served a notice under section 35(3) BNSS on 23/6/2025, directing him to appear before the East Police Station on 23/6, on the same day, you say on the same day at 15 hours, at 15 hours without fail. Stop. It is stated that the petitioner was on his way to Shamator
Yes.
on that day when he received the notice. Stop. And accordingly, he could not appear before the police station on 23/6/2025. Stop. Apprehending arrest, the petitioner has approached this court. Next part. I have heard learned senior counsel, Mr. C.B. Jamir, for the assisted by such and such for the petitioner, and Mr. Tibapom, learned PP. Issue notice returnable on 14th July 2025, on which date the learned PP shall obtain the updated scanned copies of the case diary. Next part. In the meantime, the petitioner shall be released on bail on executing a bail bond of rupees 30,000 in the event of arrest, to the satisfaction of the arresting authority. And the petitioner shall also appear before the before the police station before the next date and record his statement. Stop. Next, brother. The interim order, this interim order is subject to the outcome of the final hearing on 2014.
May I please, Lordship, a copy of this order may be furnished to me.
Copy of this order furnished to the learned PP.
Much obliged. For motion from the supplementary cost list, item number 15, WPC 116.
Yeah, please, your ladyship. This is the third round of litigation on the same subject matter. The petitioners are challenging the appointment of the respondents, private respondents. The issue had arisen out of 5 vacancies of 4th grade under District Hospital Berin. We are the landowners and we have not been deprived all along. Before I go to the merit, to the impugn orders, appointment orders and approval letters, kindly allow me to give the background of the first 2 judgments of this honorable court to get a clear picture of this case. Your Honor, 5 vacancies arose, 4th grade arose in the district hospital Berin. And so far, none of the landowners have been given opportunity for 4th grade appointment in the hospital. I will satisfy your honorable court through RTI reply.
District Hospital
Berin.
Berin.
So the petitioners, 5 in numbers initially, who were landowners and who were not compensated whatsoever, had applied for the post upon the retirement of the incumbents. When their appointment was under consideration, 5 non-landowners were appointed through Pactor. So initially, we approached this honorable court, and at page 53, page 51 is the original WPC 19 to 19, 20, 21, 22, and 23. 5 writ petitions were filed. An extra 7. My lady may kindly take note at page 53.
So by a common order, it was.
Yes, by a common order, it was disposed of. At page 53, your lordship may kindly take note of, and on the bottom, link case, WPC 21, 2023, Sri K.A. Keting. I'll refer to this in later stage. Then a judgment was delivered at page 65. At page 65, I'm reading paragraph 19. I'm reading from the last 5 lines. The consideration in the considered view of this court should be made open to all this interested, including the paper respondent in this writ petition, therefore, upon due consideration, the administrative approval of the paper respondents in all the writ petitions are found to be non-sustainable in law and they are accordingly set aside. The state respondents will now initiate a fresh process for filing the vacancies in district hospital parent by inviting application from all interested persons and eligible persons to apply for the same. The applicants thereafter, upon being screened and their claim verified in terms of the stunting guidelines. Lordship, may kindly take note of that. The stunting guideline is with regard to the land ownership issued by the state government shall be shortlisted for appointment, since it will be in the interest of the public that the vacancies are to be filled up at an early stage. The state respondents are directed to complete the entire process within 3 months. Then the next page, page 67.
So the appointments were set aside.
The appointments were set aside and
Fresh
advertisement in accordance with the stunting guidelines of the government. Though now at page 67, by an advertisement dated 7 July 2024, the post was advertised, 5 vacancies. However, in the conditions given, 7 conditions, preference for land ownership were not included. Indigenous inhabitants, age, then you should reach, interview on 28 August, NOC from the respective village council, indigenous inhabitant certificate, scheduled tribe, academic documents, birth certificate, incomplete application shall be summarily rejected by the board. No separate calling letter will be issued. 1, the application should be an indigenous inhabitant of the concerned area as per the office memorandum dated 26 October 2017. Then next page. We came to the dishonorable court again, in view of the fact that no preference were given against this advertisement. Now 160, 5 applicants, petitioners, Lordship Mechanism serial number 2 is that's Sri K.A. Keting, earlier who was.
Yes.
Then by judgment dated 26/11/2024, kindly allow me to refer to page 70, the operative paragraphs. I have considered the submission made by the learned counsel of both sides. It is admitted fact that landowners of or their family members who had donated land to the government get preferential treatment. If otherwise found eligible for appointment in grade 4 posts, the state respondents did not mention that fact in the impugned advertisement. It should have been done by the state respondents. Therefore, the advertisement dated 7/7/2024 published is bad in law and therefore stands quashed. Accordingly, the state respondents are directed to publish a fresh advertisement where it shall be mentioned among other conditions regarding eligibility that the landowners or their family shall be given preferential treatment if otherwise found eligible for appointment. In the present petition have already completed 35 years, that is for continuation. Therefore, the prayer for direction of the upper age limit should be relaxed for them only. To that effect, the petitioners has pointed out that by the notification dated 5/10/2024, the government of Nagaland has already made the upper age limit for Group D up to 37 years. Accordingly, the petition was disposed of. Then, page 73.
So that advertisement was quashed.
Yes, advertisement was quashed and to give preferential treatment. Yes, the second paragraph. Then page 73, the fresh. Kindly allow me to read the advertisement. At page 11, page 73, advertisement dated March 2025. Merit. In pursuance of the government department dated 24 February 2024, applications from the indigenous inhabitants of the district are hereby invited to fill up 5 posts of grade 4 given to law under the establishment of the medical superintendent. This is in accordance with the honorable judgment dated 26/11/2024, passed in 1/60/2024, such and such. Then the conditions, 1, should be an indigenous inhabitant of concerned area as per the notification dated 4 June. The other conditions are same. Kindly allow me to read condition 6 again. The candidates are hereby directed to bring the above following documents in original: NOC from the respective village council, indigenous inhabitant certificate, scheduled tribe, academic documents. Incomplete application shall be summarily rejected. Lordship may kindly appreciate the fact that B and C, indigenous inhabitants certificate and SC certificate, after the 4th June 2016, a new format has been, should be read with 1. A new format was issued, and accordingly, fresh indigenous and SC was issued for all who had applied prior to 2016 in terms of the 2016 notification. Then 7 was added. Amongst other conditions regarding eligibility, that the landowners or their family members shall be given preferential treatment if otherwise found eligible for appointment. So my respectful submission is still submit your application if, in terms of the condition in the advertisement, if they are found eligible, then preferential treatment to be given to them. Then, Lordship, we have submitted our applications from annexure 12 to 716, where we have submitted our application on the basis of land ownership against the interview. Then we came to know from the newspaper, Lordship, that, and now before that, at page 79, page 78, an RTI was filed on 12/3/2024 to find out. Lordship, kindly allow me to read paragraph question number 3 at 16. How many persons were appointed grade 4 on land ownership basis since the establishment of PHC till upgradation to district hospital? Kindly furnish the appointment along with the supportive documents. Then the reply is at page 81, query number 3 at page 81, nil. So till date, and the appointment orders have been annexed, till date, not even a single person has been considered for the landowners, on land ownership till date. Now, thereafter, interview was held on 26 March. Only oral interview was conducted, and we came to know, thereafter, we came to know that from the newspapers that except for KAKT, the 4 petitioners were not selected, and 4 non-landowners were selected by the interview board. Accordingly, at page 102, we filed an RTA application to immediately we submitted an application representation from page 94 and next to 18 onwards to save time and not reading it. But I filed an RTI to collect all the informations on 6/6/2025 at page 102. Then by an RTI reply on 19 June at 103, annexure 23, we obtained all the informations, the appointment orders and all that. Now, Lordship, may kindly allow me to refer to page 157 first. This is the meeting minutes of the board. 157, which I'm challenging. The Departmental Screening Committee sat for interview on 26 March 2025 as NHP conference hall for appointment of 5 grade 4 posts under medical superintendent, 3 posts of medical attendant, 1 post of MTS, 1 post of lab attendant with the following members: additional director such and such, joint director, deputy director, registrar. Lordship, not even a single representative from the BNR and others are present in the board. It is exclusively a departmental interview board, which is contrary to the notifications of the government. This is in compliance with the Honorable High Court judgment dated such and such passed in capability such and such with the government approval for a re-advertisement to conduct interview. But this is the issue. The following candidates has been selected on merit basis. Then private respondents are in 1, 2, 3, 4, and one of the landowner at 5. So, Lordship, as per the direction of this honorable court, if the landowners are found eligible, they are also to be given preference. So that was not given purely on the basis of merit. Then, Lordship, at page 169, it was approval letter was given. Marks, Lordship, if necessary, I will point it out. It is all there. But for the moment, at 169, the government's approval letter, may I read? Administrative approval on the meeting minutes of the interview result conducted for the 5 posts. In inviting a reference to the subject cited above, I am directed to convey for approval of the government for selection of 5 candidates on merit basis for appointment to the various posts of medical superintendent subject to conditions. The private respondents are 1, 2, 3, 4. Since respondent number 5, since he is one of the landowner, I'm not challenging it for him. Challenging it since he himself was one of the writ petitioner earlier. So I'm not challenging, I'm only challenging for 1 to 4. Then the approval letter, impugned approval notification result was declared. Next, at page 170. This is the, in compliance, this order was issued then, Lordship, from page 171 till 174, the appointment order, impugned appointment order was issued on 12/6/2025. Secondly, Lordship, going through the documents which I have received through RTI from page 106. 106 relates to respondent number 8 through RTI, which was served to me. It clearly shows that it was not that the petitioner respondent number 8 is not a landowner. He did not apply on the basis of land ownership. The documents are all enclosed up to 1.
No, but see, that memorandum, have you enclosed that landowner guideline?
Yes, yes, it is enclosed. It is enclosed. Lordship, may kindly allow me to refer to that
Enclosed.
at page 42.
42. See, according to this, only one landowner can be appointed.
Lordship, the point is this. The point is,
So
I'm going to clarify on this because your Lordship has asked a very pertinent question. Lordship, the land, there are multiple landowners. Various landowners is donated, is not a small plot. So multiple landowners is donated the plot, their plot of lands, and till date, till date, all those landowners who had donated the land for construction, because along with the hospital, the private quarters and other things, so the land where the district parent hospital is situated belongs to several landowners. And till date, not even a single individual has been given appointment. Now, as per the government notification, it says that for a landowner, they are entitled for only one. It cannot be hereditary, or they should not be given any privilege, any contract, or any facilities. So far, in the previous writ petitions, it has been satisfied. This honorable court was satisfied in the previous 2 writ petitions. This issue has already been settled by the previous 2 writ petitions that they are genuine landowners, and till date, they have not been given any facilities whatsoever. So accordingly, they come within the purview of OM dated 16 August 2018. That has been settled already, Lordship, by the previous rule.
No, it's like this. If supposing a department may have a big plot of land.
Yes.
And the office of EE may have a different landowner, SDO may have
Yes.
a different landowner, for
Yes.
example.
Yes.
Then in that case, the different families
Yes.
will be given the appointment on that basis. But
Yes.
if it's one family only,
It belongs to different families. That is the issue, Lordship. The land belongs to different families. That is how they all made their claims. And that ownership, that issue has already been decided in the first 2 writ petitions. That the land belongs to different families, and not even a single person has been considered so far. If Lordship may kindly see the first judgment, that will explain everything.
judgment, speech.
First judgment is page 51. In fact, Lordship, If Lordship may kindly satisfy Lord.
We will examine if you notice and
My Lord,
you have an interim prayer.
I'm praying for an interim, I'm praying for an interim to suspend the impugn of appointments of the private respondent until the final disposal of the case. Lordship, you
Yes,
kindly,
it will be subject to.
Lordship, you kindly appreciate the fact that through RTI, it was supplied only on 19th.
Yes, because this court on many occasions has already upheld this one post, one person appointment.
Because the point is,
And even for, even in cases where different families, 3-4 fathers were there, we have, this court has upheld that only one person can be
Lordship,
appointed. So in these circumstances.
Lordship, the
I-
judgments,
We will have to examine. properly.
that is fine, but
So only subject to the outcome.
because
At best.
Because in the previous two writ petitions, the claims of the 5 petitioners has been upheld. In the first writ petition, Lordship may kindly appreciate that fact. That is how the five appointments of in the first writ were quashed and set aside. If it is only one claim, Lordship, all the 5 appointments would not have been set aside by this honorable court, rightly or wrongly. Lordship may kindly see the first judgment is page 51. Because if it was only one claim, then this honorable court would not have set aside all the 5. That's how we approach again. So that aspect may kindly be appreciated. Because the coordinate bench of this honorable court has already recognized the fact that 5 vacancies and the landowners were eligible. And in fact, Lordship may kindly see the principal director's letter. Because when all this was happening, the principal director at page 647 were processing our case to consider the interview report and consider our cases on the basis of land ownership. Because the department has verified and recognized that we are all landowners and we're eligible. Only then, at page 47 by a letter dated 14 September 2020, the principal director has directed for verification where our names also figures. So department has already recognized that we are all landowners eligible. That was the basis in the first writ petition. That's how all the 5 that is how all the 5 appointments were quashed and set aside.
Yes.
Leadership, as far as I think, as my lady has rightly observed, I fully agree with my ladyship that this petition may needs proper adjudication, because there is also in the first judgment which my senior friend has.
But you have also not sought any review or any appeal against that.
And Lordship, we can.
That first judgment.
And Lordship, we can.
There.
Yes, please. I'm sorry.
Having said that, probably that judgment was not placed before this honorable court when it was placed. Otherwise, as my lady has observed, one post, be it may be a joint donors, but one post was already upheld as early as 2019.
Yes.
Like even by division bench. So, and even here, there's a whisper of land donation, appointment of landowners at page 61 in paragraph 2012 of the judgment.
And another important.
So my humble submission is, let notice go at this juncture, but as far as interim is concerned, as my lady has observed, let it be subject to the outcome of the writ petition. Though I pray that a blanket.
Lordship, may kindly appreciate another fact. My final submission. Lordship, the judgment of this honorable court in 160, the second judgment, which is
Page 68.
Page 68. Lordship, kindly allow me to read the last paragraph, the operative paragraphs. May I read the last paragraph? Therefore, the advertisement, page 70, at page 70, therefore the advertisement is bad in law and therefore quashed stand squashed. Accordingly, the state respondents are directed to publish a fresh advertisement where it shall be mentioned among other conditions regarding eligibility that the landowners or their family members shall be given preferential treatment. It is plural, not singular. If otherwise found eligible for the appointment. In the present writ petitioners, Lordship, the conditions, thereafter Lordship may kindly come to the condition at page 73. 7. Among other conditions regarding eligibility, the landowners or their family members, landowners or their family members, it is not singular, it is plural, shall be given preferential treatment if otherwise found eligible. Now, if your Lordship may kindly see thereafter the meeting minutes, again, meeting minutes of the department, which is at page 157. Now, Lordship may kindly allow me how the exam, what is the constitution? This another important fact, Lordship may kindly also see at page 45. How a fourth grade board has to be constituted. Chairman, Lordship, this is the constitution. Now, Lordship will kindly come.
So you're saying that PNR member was not there?
PNR member is not, and the rank also, Lordship, is clearly mentioned. It is only a departmental in nature, that is one. Secondly, Lordship, Lordship, the interview board had the interview board did not comply with the direction of this honorable court because Lordship may kindly see the following candidates has been selected on merit basis. Nowhere in the minutes of the interview board they are talking about, it is discussed about consideration of the landowners or to give preference to the landowners because the direction was that open interview to be conducted, and if the landowners are otherwise eligible, then he should be given preference. So that aspect of the judgment has not been considered at all. And most importantly, Lordship, how merit can be determined through an oral interview, because since no written interview was conducted, oral is only for determining the personality, to examine the personality of the candidates, but no written examination was held. In fact, Lordship, may kindly allow me my submissions. Lordship, at paragraph 6 at page 15, what questions were asked to us? My Lord, at page 17, at paragraph 9, I have already mentioned what were the questions asked to us. It was purely a general question being asked. No written was conducted, and oral, and how on the basis of oral merit can be determined. No oral was conducted. No. Lordship, may kindly, paragraph 12, page 18, merit. Bottom of the fourth line from paragraph 12, page 18, a mere perusal of your applications, such
Para 9. Page 17.
Page 20, Lordship, page 20. Page 20, Lordship, on the bottom. The oral interview, it is purely subjective and non-objective is not objective in nature, and the interview was conducted in the preconceived mind of the interview board and members under extraneous consideration. It is most respectfully stated that the oral interview is only to test the personality of the candidates, and it alone cannot determine the merit of the candidates in the absence of any written examination. So my respectful submission is, prima facie, the appointment order and interview was purportedly under the direction of, in compliance with the direction of this honorable court. But whether the directions of this honorable court in WBC 160 has been complied in letter and spirit, that also has to be taken into consideration, because in my respectful submission, the interview was conducted in clear contravention of the direction of this honorable court in WBC 160. The land ownership, the interview board minus is totally silent on whether the landowners were found, any of the landowners were found eligible or not, and if eligible, whether preference has to be given. Condition 7 of the advertisement, that was totally left out.
No, maybe the one who was selected was more meritorious than the other landowners.
My lord,
Yes.
I will satisfy the lordship from the report, but whether the minutes say so, that is, I'm confining to the minutes, not the interview report. Whether in the minutes of the interview report, it talks about preference to the landowners.
The private respondents might have already joined the service, so just giving the
No,
blanket.
subject to outcome, that
Yes.
I've already made up my mind.
Yeah, then
This
that is-
petition has been filed by the present petitioners who are claiming to be landowners who had donated the land free of cost for the establishment of parent district hospital parent. Stop. It is stated that the petitioners had filed WPC 19 of 2023, WPC 20 of 2023, WPC 21 of 2023, WPC 22 of 2023, and WPC 23 of 2023, which were disposed of by a common order dated 12/2/2024, quashing and setting aside the appointment orders of the private respondents, and a direction was given to initiate a fresh process for filling up the vacancies by inviting applications from all interested and eligible persons to apply for the same. Stop. In compliance, the Principal Director, Directorate of Health and Family Welfare, had issued an advertisement number DHFW-3/court-case/parent/GR-4, Roman 4/7519-26, dated 7/7/2024. The advertisement dated 7/7/24 was silent on the land ownership rights of the petitioners, and therefore the present petitioners again approached this court by filing WPC 160/2024. Stop. A coordinate bench of this court heard the matter and disposed of the same by order dated 26/11/2024, and had quashed the advertisement dated 7/7/2024, and the state respondents were directed to publish a fresh advertisement wherein it was to be mentioned that the landowners or their family members shall be given preferential treatment if otherwise found eligible for appointment. In compliance, the state government issued the advertisement dated nil March 2025. Stop. However, by the impugned interview minutes dated 26/3/2025, impugned administrative approval dated 15/5/2025, and the impugned notifications dated 28/5/2025, private respondents were appointed solely on the basis of merit without considering the landowners, and the impugned appointment orders dated 12/6/2025 were issued. Stop. Next para, I have heard learned senior counsel, Mr. Takamasa, assisted by Mr. Arn Long, and learned government advocate, senior government advocate, Mr. K. Angami. Stop. Next para. Issue notice to the respondents 2, 3, and 4. Oh no.
Leadership and for respondent number 1 to 7.
Respondents number
1 to 7, then
I'm for 1 to 7.
You are for 1 to 7.
Yes.
Respondents issue
8
notice
to 11.
respondents number 8 to 11. Stop. Learned government advocate, the senior government advocate accepts notice on behalf of respondent number 1 to 7. Therefore, no formal notice is called for. Stop. The notice is made returnable. Did I say returnable date? Returnable within 4 weeks. Stop. The appointments of the private respondents. shall be subject to the outcome of the writ petition.
Lordship, with regard to notice upon respondent 8 to 11.
Yes, the petitioner shall take steps for notice on the private respondents by registered posts with AD as well as usual process within a period of 3 days.
3 days.
3 days from today.
Much obliged.
Please, Dr. Foley.
For motion from the supplementary cost list, item number 16. WPC 118.
May it please, my lord. Lordship, this is a peculiar case. The petitioner number 1 and petitioner number 2, they are president and general secretary of the Nagaland Amateur Boxing Association. Now, this Boxing Association of Nagaland, Lordship, is affiliated to the Boxing Federation of India. Now, the Boxing Federation of India is further affiliated to World Boxing, that is at the international level. And in India, it is also, the PFI is also affiliated to Indian Olympic Association, because all the national level sports discipline, they are affiliated to Indian Olympic Association. Now, due to the delay in conducting elections to the Boxing Federation of India, that is the national level federation, interim committee was set up by the World Boxing Federation, which I have annexed at Annexure 5. This is important. Here, that interim committee has been given 10 responsibilities, or let me say 10 terms of reference. And that interim committee was to function specifically under those terms of reference in order to restore the Boxing Federation of India. Now, for that restoration, an election is required, which is to be voted by the state level boxing, amateur boxing associations of all the states across India. Now, we don't know, but perhaps the interim committee, they wanted to install some puppets. So, who will favor them in the upcoming election, which is to be conducted imminently in July. So, the interim committee of the PFI appointed one ad hoc committee at the state level, which has virtually resulted in dissolution of the NAPA, the Nagaland Amateur Boxing Association. The impugned order is at page 33, Annexure 8. Though they have used the word notice. Notice means, as my lord is very much aware, is information or an intimation in advance. Or it can be a show cause notice, but it is misleading. It is an order. It is instruction, a direction. This notice is to formally announce the formation of an ad hoc committee in the Nagaland Amateur Boxing Association. This ad hoc committee has been formed to oversee and administer the daily affairs of the Nagaland Amateur Boxing Association until conduct of NAPA's elections. So, at the state level also, both at the national level as well as the state level, elections are due. Our tenure has also lapsed on 31st of July 2025. However, we have made efforts to conduct elections for electing the new office bearers and executive council of NAPA. However, only at that point of time, only 3 districts were affiliated to NAPA, which is why a resolution was made. I have annexed the meeting minutes as well. that we will make efforts for inclusion of more districts. At this juncture, as of today, 7 districts have already come forward and is presently affiliated to NAPA, and more districts, 3 or 4 of them, they are already under process. We are aware of that for affiliation to NAPA. And in fact, a newspaper publication was also made, which I have annexed at Annex 4 on January 16th, 2025 in Nagaland Post, which is the leading newspaper in Nagaland. Page 27, inviting interested candidates for various posts. But there was very low participation, which is why we again, through a meeting, postponed it. Now, at this juncture, even at the national level, the interim committee only has to function as per the terms of reference, the 10 responsibilities given by the World Boxing, the International Boxing Federation. But they have gone way beyond it and have dissolved, in essence, dissolved the NAPA office and have constituted an ad hoc committee. Now, and
The committee has been formed as no election has taken place in the state.
yes. Now, this was also
No, the
issued.
tenure is 1 year,
No. It is 4 years.
years.
Yes,
So 4 years will expire when?
31st July,
31st July.
2025.
Not yet expired.
No, 2024.
Oh, that means expired already.
Yes, it has
that 4
already
years.
expired. Yes, it has
Then
already expired.
what right do they have to continue?
No, I'll come to that. I'll come to that. One, it happens on many occasions, in fact. Not the office not being able to set up the new office in time. However, there are rules which clearly states that show cause notice must be given. Only after that, dissolution or de-affiliation or any disciplinary action can be taken. Now, Annex 8, the impugned notice order is issued by the executive director and member interim committee PFI. Now, this position, this particular post, is not a post within the rules and regulation of the Boxing Federation of India. I have annexed the rules and regulation of the Boxing Federation of India in the very next page.
This annexure 8.
This is annexure 8. Annexure 9 is the rules and regulation of the BFI.
Issued by executive director
Yes,
and member.
yes, and member interim
Interim
committee BFI. Now, this post is not the post under the rules and regulations of the Boxing Federation of India. Perhaps it could have been issued,
Not the post under the rules and regulations.
yes, of the Boxing Federation of India. We have various posts like President, General Secretary, Secretary General.
Where is it?
The treasurer.
The various office members, the designations, is it given here?
Yes,
Executive council members and also.
page 43.
President, Secretary General.
One treasurer, 8 zonal presidents, 8 zonal joint secretaries, 2 accredited representatives from each member. They have an executive council. Now, executive director It's not a post here.
Because this is also an interim committee. Interim committee. That means the BFI, the present office bearer's term is also over.
Yes, it's over, which is why the interim committee was
That's why
constituted
there's
by
an
the,
interim
yes,
committee.
boxing,
Yes.
world boxing.
Yes.
Now, 10 responsibilities were given. That means the interim committee has to function as per
Where
those,
is that 10 responsibilities?
Annexure 5, page 28, my lord.
Page?
Page 28, page 28. I may be
Yes.
allowed to read. The interim committee should be entrusted with the following responsibilities: day-to-day management of BFI's affairs, ensuring administrative continuity. 2, organization of domestic boxing competitions, including national championships, in a fair, transparent, and inclusive manner, and taking all steps necessary to ensure participation. 3, selection of Indian boxing teams for international events on the basis of selection policy in a timely manner. 4, coordination with Sports Authority of India, Indian Olympic Association, and relevant national stakeholders to protect the interests of Indian boxing and its athletes. Overseeing financial matters, including the operation and management of BFI's bank accounts to ensure transparency and discipline. 6, representing BFI in all ongoing and future legal proceedings with the authority to act in the interest of the Federation. 7, initiating the revision and alignment of the BFI constitution in line with World Boxing statutes and Indian legal requirements. Resolve issues related to the registration and legality of Indian boxing body. Ensuring India's preparedness to host the World Boxing Finals and World Boxing Congress, both of which remain important milestones for Indian and world boxing. 10, facilitating the conduct of free, fair, and legally compliant elections for the BFI at the earliest feasible opportunity. So, at the cost of repetition, this interim body has to function only as per this 10 terms of reference. But they have gone very much beyond it and have dissolved the NAPA office and appointed the ad hoc committee at the state level.
Okay, and where is the provision that even after your term is over,
Yes,
you can function?
I'll come to that. I'll come to that. The rules and regulation of the Indian Olympic Association. I have flagged the relevant rule. Rule 26. The top of the page, page 28. National Sports Federation / State Olympic Associations as one or more of the undermentioned grounds and after ensuring that a show cause notice has been served and an explanation has been obtained and considered from the organization recommended for this affiliation, derecognition, suspension. So a show cause notice is mandatory. After ensuring that the show cause notice has been served. Now, under these 5 conditions, such as the disaffiliation, derecognition, suspension can be taken. 26(1.2) is important. It directly concerns us.
Okay. Who accepts notice? You are accepting notice, young man?
For the union of it.
For,
For the union list, respondent number 1.
that is respondent,
Respondent 1.
respondent 1.
My lord,
Yes.
a similar matter has been brought up before the Delhi High Court. Stay has also been granted in Delhi High Court. And regarding Delhi Amateur Boxing Association and the Boxing Federation of India. Now, again, in Manipur High Court, this is not to do with boxing, but which is also an association under the Indian Olympic Association, that is Fencing Association of Manipur. Here also, similar things have been done. The solution was done, ad hoc committee was set up, there was delay in the conduct of election. The High Court interfered in the matter, and all those impugned orders, they were questions set aside. I have the judgments, the Delhi High Court decision I have annexed in my petition.
Because
Annexure 10, page 60.
page 60.
Page, yes, 60. Here also, because of the dissolution, the members were denied voting rights. 60. The relevant paragraph is at paragraph 41, page 71. Considering the submissions made before this court by learned senior counsel for the petitioner, as also by learned counsel for respondent number 2, this court is of the view that the prima facie case is established by the petitioner in its favor. Prejudice shall be caused to the petitioner if the petitioner is not allowed to participate in the election process. Accordingly, 43, paragraph 43, accordingly, the operation of circular dated so-and-so issued by the respondent number 1, BFI, is stayed till the next date of hearing. The Manipur High Court decision. Yes. It's a lengthy judgment, but I may be allowed to refer only to one single paragraph at page 48. The title is self-explanatory, the Manipur Fencing Association versus the Fencing Association of India. Page 48, paragraph 14. In view of the above and for reasons stated herein above, the instant writ petition WPC so-and-so stands allowed in part and consequently the portion of the impugned order dated so-and-so towards the dissolution of the petitioner association, the disaffiliation of the petitioner association, and the appointment of the ad hoc committee is quashed and set aside. My humble prayer today is that, my Lord, the impugned notice/order, because despite the fact that they have used the word notice, it is an order. It is a direction, an instruction, a direct instruction. It may be stayed till the next reasonable date in the interest of justice. Otherwise, irreparable damage shall be caused to me.
The present petition has been filed by the petitioners who are the president of Nagaland Amateur Boxing Association under bracket NABA, NABA close, and the
General Secretary.
General Secretary of the NABA. Stop. It is stated that the NABA is affiliated to the Boxing Federation of India at the national level. The Boxing Federation also you write BFI, okay, in brackets. And the BFI is affiliated to the World Boxing Association at the international level. Stop. The BFI is also affiliated to the Indian Olympic Association, as is all national level sports federations of all disciplines. Stop. It is stated that the Indian Olympic Association is recognized by the Ministry of Youth Affairs and Sports of the central government. Stop. It is submitted that elections for the office bearers of NABA is conducted from time to time, and the last election was conducted in the year 2020. The term of the present office bearers expired when?
31st July 2024.
31st July 2024. And the elections for the next office bearers will be held sometime in July. Will be
Yes,
held
yes.
sometime in July 2025. Stop.
If
It is stated
July,
that-
if it can be July/August.
July/August 2025. Therefore, the petitioners are still continuing as office bearers of the said NABA. Stop. While matters were pending, thus it is stated that a notice has been received from the interim committee of the BFI
Uh,
dated,
My lord, if it can be executive director and member interim committee, PFI.
no, just wait. A notice has been received from the interim committee of the Boxing Federation of India dated 18 June 2025, signed by the executive director and member interim committee, Boxing Federation of India. Stop. It is stated that the executive director, Boxing Federation of India, has no legal authority or jurisdiction under the rules and regulations of the BFI to unilaterally dissolve, remove, or disqualify any member of the Executive Council. However, by the impugned notice dated 18 June 2025, an ad hoc committee has been constituted for the state of Nagaland to oversee and administer the daily affairs of the Nagaland of the NABA until the conduct of the NABA elections. Stop. The notice also states that the ad hoc committee shall be responsible for administering the number one, administering the day-to-day affairs. Number two, selecting the team for participation in the national championships. Number three, affiliate at least 50% district associations with NABA. Number four, to bring NABA's constitution in alignment with BFI constitution. Number five, conduct elections for the Executive Council of NABA. Stop. By this impugned order, an ad hoc committee has been constituted with three members who three members, and the present petitioners are not part of the same. Stop. It is stated that this impugned order has effectively removed the present petitioners as office bearers of the NABA. So I have heard learned counsel for the petitioner, Shri Santiyanga, and Mr. Yangarwati, learned CGC for the respondent number one. Stop. But it is also the case of the petitioner that according to the memorandum and rules and regulations of the Indian Olympic Association, such an action can be taken for derecognition / suspension or disaffiliation only through the provisions of rule. This is rule.
Yes,
26.1. Rule 26.1 of the aforementioned rules and regulations, which states that a show cause notice has to be served and explanation to be obtained before taking such action, and which includes not holding elections after the completion of the normal tenure for which the office bearers are elected. Stop. It is therefore the case of the petitioner that the petitioners could not have been removed as office bearers of the NABA through this impugned notice dated 18 June 2025. Stop. Issue notice to the respondents. Who are the respondents? Respondents
2, 3, and 4.
2, 3, and 4, returnable within 4 weeks. The petitioner shall take steps for notice on the respondents by registered post with AD as well as usual process within 3 working days. So in the interim, the notice, impugned notice dated 18 June 2025 issued by the Executive Director and Member Interim Committee, Boxing Federation of India, shall remain state till the next returnable date.
Deeply obliged.
Shall I keep this in the
Yes.
record?
Much obliged. अच्छा, betul. Kami kita ada program itu. Saya mau bertanya lagi, अच्छा, एकता sih ada.